It's great to be here to talk about this topic. I'm Professor Janis. This is Professor Hedges. We're recording this at IU. Oftentimes we get to come up to Purdue. Couldn't do it for this time, but we'll make the best of it. We often get asked to talk on this topic of patents, and usually it's to an audience of engineering students. And we understand that a lot of you are not planning on being patent lawyers. Maybe even after you hear from us, you're not planning on being patent lawyers. But many of you who are going to go out and work as engineers are going to encounter patents in your daily routine. So the thrust of our conversation today is going to be what you need to know about patents as engineers. And if we can slip a little bit in there about what the career of patent law would be like and spark some interest there, that would be great too. So as I mentioned, we're recording this at IU. I'm the director of the Center for IP Research at IU Bloomington. As you can see from the slide, Professor Hedges is the director of our IP clinic here. As you can also see on the slide, we've got a picture of ourselves here outside of the law school, looking very serious, lawyer serious, indicating that we are from IU, we do work at IU. However, we always like to emphasize that really our loyalties lie with Purdue because we both attended Purdue as engineering students now a long time ago. So we had a lot of fun taking this picture in our Purdue garb. We've got a lot of interesting comments as people walk by on campus. But there it is. You can trust us. We're actually kind of from Purdue, even though we're doing this at IU. So here's what I thought we would do, Professor Hedges, with this. Are you going to be okay with this if we keep going here?
You got to tell me what we're doing.
Okay, here's what we're doing. So first, a little bit of basic background on patents so that we're all in the same, all on the same page. All two of us here and our fake engineering students, some of them really are engineering students, but there are law students here who are here to keep us company as we do this recording. And so we're going to do that first, and then three scenarios for you to consider. And we picked these three not because it covers every patent issue that you can think of. We'll have to leave a lot of things out. But there are three ways that we think are really typical of how engineers would encounter the patent system. That's how we selected them. So we'll go through those three. We'll work with our students a little bit. And at the end, we would usually ask for questions, but there won't be any questions. We'll just stop the recording at that point. All right. And we've got a timer going because we know these sorts of classes, you cannot go overtime. We promise we will not go overtime. All right. So here are some basic things that you need to know to just have a discussion about patent rights. First of all, a patent right is a kind of property. It's a right to exclude others from exploiting an invention. It's a federally granted right of property. And it's a weird sort of property in that it has a limited term. The term is 20 years from filing for all types of subject matter. So that may strike you as kind of long for certain types of products that have really quick life cycles. Maybe not quite long enough if you're Eli Lilly doing pharmaceuticals, for example. But it's arbitrary term, 20 years from filing. And limited to the US. There is no such thing as a world patent. There are mechanisms by which you can file a centralized application under the so-called Patent Cooperation Treaty. And when those applications are published, sometimes they're published with a designation that might make you think that it's some international thing or a world patent. That is not the case. Patent rights are territorial. And that means if you're doing business all over the world, you got to get patent rights not only in the US, but you got to get patent rights in other places where you might be doing business, and that can be pretty expensive.
Professor Janis, I'm a little confused. So
only a little, you're a little
confused. So what if somebody like manufactures something outside of the US, let's say, maybe in Mexico or China or something like that. And so my US patent is not going to help with that?
US patent is not going to help with that. Now, if they import it into the US, now they're within US territory and there might be liability for that act, but otherwise, no. And that does mean that if you're serious about a potential infringement risk in Mexico, China, other companies, you've got to go to Mexican counsel, Chinese counsel, get your patent rights there and be prepared to enforce them through their judicial systems.
You get your US patent and it's not very expensive to get these other ones.
It's
Right.
totally expensive. It's expensive to get all of them because people like Professor Hedges, that he charges a lot. And so, yes, lawyer fees in addition to government filing fees for these documents add up pretty fast. So we're talking about thousands of dollars for one of these patents, and then you can multiply that by probably however many countries you think you'd be doing business in, and you can see that that's just one of maybe many patents that you would need to get to protect your product. So it's a very expensive proposition. Part of the reason it's expensive is that to get a patent, you have to apply to the pertinent patent office, so the US Patent and Trademark Office in the US. And it's not just a matter of filling out a form. It's a custom drafted document. There's a lot of strategic consideration that goes into the drafting of it, and you need an expert to draft it. So a lot of the fees that we're talking about, separate of the government filing fees, are fees that you're paying to the lawyer, hopefully a really good lawyer, Purdue trained lawyer, let's say,
The best kind.
to draft these patent applications in such a way that you have a significant, commercially significant protection for your invention. And now, one other thing that you see on the slide there is the way that these rights get enforced. So like many other types of property, they're not self-enforcing. You have to go and do something to enforce them. And the doing something might very well be suing somebody else for infringement in a federal district court. There's a special appellate court, the Court of Appeals for the Federal Circuit, that's noted on the slide there. But this is an expensive proposition.
So we talking another couple $100,000 to do the whole enforcement thing?
Barely, it won't even get you through the doors of the courtroom, basically. So we're talking about a couple of $1 million to take a patent trial from beginning to trial. And then it would be more on top of that for appeals. And that's probably just an average. A complicated patent trial would be more than that. And those are attorney's fees that both sides are going to pay. And it's very rare in civil litigation, particularly in patent litigation, for you to get your fees paid for by the other side, even if you win. So you're going to be paying that out and you're not getting that back. So one of my fake students has a question.
Is there a time period that you must enforce in once you find that there's infringement?
Well, so during the term, you can force it anytime during the term, but you can only go 6 years back from the time you file a lawsuit. And so you can see that there's a certain amount of vigilance that you need to exercise. And of course, how are you going to do that? That's probably through lawyers and through a regular conversation with lawyers, and it could be expensive. Now, I don't want to suggest that the only way that you ever would enforce a patent right is through a lawsuit. Certainly, there are many other ways. There are license negotiations. It could be alternative dispute resolution, lots of other ways that you would enforce these rights. But the main point here is that the government is not going to do it for you. You got to be the one enforcing these rights. So if you are running a tech-heavy business in most areas of technology, part of your budget has to be devoted to getting patent rights for the technology that you've developed and want to protect, but also being prepared to enforce those rights and maybe defend yourself against allegations of infringement. It's part of the cost of doing business, and it can be a pretty significant cost. So that's part of it. Now we've got another slide here that talks a little bit about who patent lawyers are. And you want to go through that, Norm?
Yeah, so as far as being a patent lawyer, by and large, most patent attorneys have technical backgrounds of some sort, some sort of science or engineering background in order to be a patent lawyer. There is now a new special carve out with people that have artistic backgrounds, maybe architectural backgrounds. They can file what are called design patents. But by and large, the vast majority of the work is for people that have technical backgrounds. So you're gonna have that at the bachelor's, perhaps the master's level as well. In addition to that, you're gonna have to go to law school for 3 years in order for you to be able to sit for a state bar exam, because you are a patent attorney, just like any other attorney that has to sit for a bar exam. That's 3 years out of your life, and it's 3 years of not being compensated for that, and there's some tuition in there and that kind of stuff. So it's not a risk-free endeavor. It can be some financial consequences there. But if you see the last bullet on the slide there, starting patent attorneys can expect, start out at 180 or maybe a little above that or a little below that, depending on which market you're in. And most engineers top out in kind of that $130,000 or $140,000 range in their career. So you can see that as a patent attorney, you're already starting out at or above what other engineers are making, and the compensation goes up from there. And so it doesn't take too long to make up for that lost income and stuff, and the tuition and all that goes along with being in law school as well. So typically, most patent attorneys start out in what's called private practice, and that's just a reference to law firms. After a while and gaining some experience, some of them may go in-house, which means you might go in to work for a corporation. And then once you're in the corporation, who knows where your career could take you. You could end up, specializing in patent law for your whole career, or you could specialize in addition to patent law, other areas of IP, and you could end up being the lawyer, the IP lawyer for you. So you could be doing trademarks and copyrights, maybe some data privacy, some other tech related things in your practice. Or you could even go beyond that and start doing other areas of the law and kind of end up finding yourself as a general counsel as a business, and maybe even ultimately the CEO of a business as well. So, but lots of different avenues to go once you go in-house as well, in the private practice as well. So typically, if you're a patent lawyer, though, in a law firm, you are going to kind of specialize in particular area of the law, whether it be patent prosecution, which is this back and forth with the Patent and Trademark Office in an effort to obtain patents. You might do some client counseling where, a client might be concerned about infringing somebody else's patent. And we'll talk a little more about that later on. And so you're trying to figure out, whether or not there's an infringement risk there. And if there is, what's the level of risk too. And you might be getting into some licensing negotiations where you're writing contracts and agreements for clients to either license out their own technology, perhaps license other people's technologies. You might get involved in merger and acquisition projects where you're targeting a company to purchase, but you don't necessarily want to be purchasing a patent lawsuit if you adopt their technology. So you want to know what the risks are involved there as part of that as well. So, Lamea.
I have a question. You talked about licensing. Do I need to have a technical background to do licensing for a corporation?
No, you don't. So the only requirement to have a technical background is this back and forth, the prosecution with the Patent and Trademark Office on technical subject matter. And quite honestly, you don't have to have a technical degree in that technical background or the technology you're working on, but I don't recommend stepping too far out of your lane, because then you're maybe committing malpractice and doing bad things. But yeah, there's all kinds of IP, including in the patent space, where you don't have to have a technical background. One of them is in the licensing and negotiation of contracts. The other is in patent litigation, where you're out there either enforcing someone's patent or defending against accusations in the courtroom, doing all those sorts of things. And you don't need to have a technical background for that. Now, there's arguments one way or the other as to whether it's beneficial to have a technical background in patent litigation or not. And there are good arguments on both sides of that as well. So, but yeah, you can find yourself in a very specialized area of patent law, even beyond the back and forth. Even after a patent issues, there are special mechanisms to challenge patents in front of the patent office. That is kind of halfway in between this patent prosecution and patent litigation as well. So lots of different avenues that you can find yourself into, and hopefully steer your career in a direction that finds it be most rewarding for yourself.
Well, so let me summarize it this way. So if that sounds interesting to you as a career path after your technical degree, then that's great. Contact us. We can talk with you more about that. If you say, well, no, I'm not gonna go that career route yet, I'm gonna go work as an engineer. What we really wanna impress on you is that when you are having a conversation with a patent lawyer, you should expect that the patent lawyer can talk with you as a fellow engineer, or as some, even if they don't have the degree, they should be able to carry on a detailed technical conversation with you. And if you're not having that, you go find another patent lawyer, because that's the level of sophistication that's expected in our profession. And I think it's good. It should make it easier for engineers to work with patent lawyers, and it's just more interesting overall. So those were things that we want to make sure that we conveyed. Let's talk about 3 scenarios here. Here's,
Janice,
yeah.
who's the guy in the?
well, you gotta, I stole that from you, so you gotta explain the cartoon background of that.
Oh, I think that's Calvin's dad.
Calvin's dad, of
Calvin
Calvin
and
and
Hobbes,
Hobbes,
yeah. And it turns out that in the Calvin and Hobbes cartoon strip, that Calvin's dad is a patent attorney. And so for those of you that are looking for some awesome, patent humor, Calvin and Hobbes is your go-to place to find that awesome patent humor, because it does find its way in there. Because Bill Watterson, the author of Calvin and Hobbes, his dad was literally a patent attorney. And so he pulled some of his dad's, awful patent humor into his comic strip as well. So
It's a good thing, I mean, because you can't watch Law and Order and expect that you're gonna see much patent law in that, right? So we gotta go with cartoons in our business, so. All right, good, so 3 scenarios here. Here's topic number 1, and here's why we picked this one. You're working, it's your first day working as an engineer. This is a happy day. You're finally getting paid to do what you were paying to do at Purdue. You're probably getting paid pretty handsomely. It's all great, all right? So like in the old days, you would physically go in and they would hand you like a stack of actual documents. Today, I don't know, maybe you're working remotely and they email it to you or something, but whatever. In any event, that you're gonna be asked to look over some big, huge stack of documents. It's gonna be insurance, it's gonna be where do you park, it's gonna be all this other stuff, all right? And I think for most people, you're flipping through it, maybe you have to initial it, but you don't have time to read all that stuff and really ponder it, like what, do I really like the company's insurance, or would I rather do something, usually you're just whizzing through that stuff. Well, one thing that you're likely to see in this whole set of documents is something that looks like this, which maybe will come up magically in the next, okay. So some language that looks something like this. Now, we didn't make this up. We found this in an actual employment agreement. And let me just turn to my actual law students, fake engineering students, though they really did go into engineering. I shouldn't call them fake engineering, but whatever. So let me turn to our students who are in the room. And I'm gonna ask you to just read through that. And maybe you could pick out for me a couple of phrases in there that jump out that you could read out loud to us. Jacob, you wanna do that? That really jump out. And then there's another paragraph that will come up. You could put that on the slide too, of similar ilk. So just read that out for us. And the question is gonna be, you're sitting there, do you sign this? Do you sign off on this? Go ahead and read out.
Read the whole thing or just something?
No, just read the parts that jump out.
Something that jumps out to me is during your employment with the company, like what does that mean if I'm just, if they hire me, but I'm making something in my garage at home, do they own that?
All right, so you gotta worry about that. What else jumps out at you?
All right, I guess also that the company doesn't have to acknowledge, or it's not required to acknowledge my role in the creation of anything. Like
All right,
if I make something, I want some credit for
Like
it.
some attribution, and they're saying they are not obligated to do that. There's language in there that says directly or indirectly related to the business of the company. And then at the bottom there, under this heading of assignment of rights, it says, it says what?
It's that I'm going to assign exclusively all my right. I guess I'm curious what assign means,
All right.
technically speaking.
Okay. And it kind of goes on in that vein, right? All right, so I really believe that literally on your first day as an engineer, you might very well encounter something like that in an actual employment agreement, or something like that in the company's policy that you're supposed to sign off on. And the question that I hope will cross your mind is, well, what is this about and should I sign this? And I don't know, Jacob, let me ask you first, are you gonna sign it?
I mean, I do want a job, so it's gonna be pretty tough for me to say no. I don't know.
Kind of hard. Do you think that if you said like, hey, I was just reading this part that says directly or indirectly, and I wondered if you could, I think I'm gonna scratch out the indirectly part, because that seems a little overboard. I mean, is that gonna fly?
I don't think the HR person would probably like that very much.
All right, I'm thinking that if it's any kind of big company, that they're gonna laugh and they're gonna say, oh, this is that's a really funny that you're gonna, look, he was gonna negotiate this, right? They're not gonna let you do that, and at some point, if you say like, no, I'm really not signing this. I mean, it seems like maybe they'll say, it's been nice knowing you for an hour in this job. I mean, it really does seem like your job could be at stake. I don't know, Sydney, I mean, should he sign it? What do you think? Or should he say like, I gotta hold out for better terms?
I mean, it's not like Jacob has a rent payment or anything that he's already lined up for
He
his new
hasn't bought a
job,
new car,
or
or,
has
yeah,
has
exactly.
deposits or anything like.
Student
And
loans.
student loans to pay
Yeah,
for or
exactly,
anything.
Exactly. So should he sign it?
I mean, I feel like you're in a predicament where you kind of have to sign it.
Yeah, so you got no bargaining power. What if we changed it a little bit and it's like a tiny startup company but everything else is the same, that they give them a stack of documents, they say sign off on it, and is it?
I think I would try to negotiate a little bit
All right, so
more.
I mean, maybe there are scenarios where you might have a little minimal bargaining power. But we know that in all likelihood, in 99% of the situations, you're gonna sign it, and maybe in the back of your mind, for many months thereafterwards, you'll be saying like, I wonder what I agreed to. Well, I'll just have to live with it, whatever. So the point of us bringing this to your attention is that you are assigning away valuable rights. So the patent law says that as an inventor, you're the owner initially of any inventions that you create. But that can be changed by agreement. And so employers, of course, when you're using their resources or you have the pleasure of being employed by them, they are gonna change that by agreement. And they're gonna make you acknowledge it, either sign it as a part of your employment agreement or acknowledge it as a part of the employment policy. And you just have to realize that that might be a problem when you go off to your next job. You're not gonna own that invention, they're gonna own it. I think it's probably largely a fair arrangement. But if you are in a scenario where you think you would have any bargaining power, you really would want to look at that carefully, think about it, and decide how you want to handle it. Now, there's one other scenario that we have for you that's related here, which comes up when you're a student. So if you're a Purdue student and you're in a class, you might very well make an invention. Purdue's policy says that for employees, and that would include grad students, they own the inventions that you make unless there is some agreement to the contrary. But there's an interesting bit of language in Purdue's intellectual property policy that does say students in classes, undertaking classes for credit, not otherwise being compensated, they own their intellectual property. And it's in our experience is a fairly unusual provision, but I think it just underscores this whole idea that you actually do own these patent rights to begin with. In a lot of settings, you're gonna be forced to assign them away, but you might like to know, what am I assigning away?
And the good folks at Purdue, for a lot of undergrads who are not employed in this research and stuff, they get to keep the rights in that. Again, that's actually fairly generous as far as university IP policies are concerned. So boiler up.
Boiler up, yeah. So the last slide in this scenario is just the takeaway points from that. And that is, understand that there's this rule that says you own the rights in your patents unless you assign them away. Understand as a practical matter, you're often gonna be asked to assign them away. All right, so that was number one. Let's go to number two. This is about reading a patent document, and the basic scenario here is you'll often find yourself as an engineer being told you're assigned to this project. Here's a bunch of patents. just review them and tell us what it's about. And that sounds like an easy thing to do because there's a lot of technical language in these documents. It sounds like it's all about reading a technical paper. But maybe it's not, and Professor Hedges is gonna tell us about that.
Yeah, so actual engineers, not fake engineers, students here in front of us. Here's a patent document. And take a little look at the abstract on there. And if you can, just kind of give me a general sense as to what this patent protects.
A typical kind of thing that an engineer would be asked to do, I think. What is this patent about? So Jacob.
So, yeah, the title says Airborne Fulfillment Center utilizing unmanned aerial vehicles for item delivery, and it's owned by Amazon. So.
I've heard of them.
Yeah, so this sounds cool. This sounds really cool.
Just looking at the picture, 'cause that's what I see, big there on the right is, there's some computer system that probably communicates with their web store and the users, and looks like a little blimp there that's gonna.
Oh, big blimp.
Big blimp.
Big old
yeah,
blimp.
Big blimp that's gonna take some of my Amazon Prime orders and drop them with a drone to my house is what I can kind of see there.
Oh, yeah.
Mamea, you were just saying that you were really excited about getting into this whole, like blimp delivery thing. So what are you gonna do?
I'm looking at this and I'm just wondering, where do I even start? It seems excited, but it also seems very complicated.
Are your dreams crushed that Amazon has locked up the using of blimps or other airborne distribution centers
Right.
for delivering packages to Jacob's house and Sydney's house and that kind of stuff? Are your dreams crushed that you can't sitting up there in the Goodyear blimp delivering packages to people via your drones?
I think it seems like Amazon has everything covered to their patent here. So yes, I am a little concerned.
Well, the good news is that the title and even the abstract are not the controlling determination as to what Amazon has locked up through their patent. What you have to do is you have to go to these things called claims here that are these numbered sentences at the end of the patent. We'll blow one of these up here in a sentence or a second, but they typically are at the end of the document. And in order to infringe the patent, you have to have everything that's in this long run-on paragraph. If you don't have something in there or an equivalent thereof, that sounds a little scary, then you're not infringing it. And basically, these claims are a way to let people know or to put them on notice as to what the patent protects so that they know whether they're infringing the patent or not. And so we've got a blow up here of one of the claims. We've pared down a little bit. And you can see in there's an airship and there's a fulfillment center that's floating in the air there. And then there's this odd thing called a presentation component on there that does some things on there. And then there's this computer that you'd have to have involved in making distributions and that kind of stuff. But there's also some more stuff buried under there that adds some detail to this. And that extra detail is that not only do you have to have a blimp or some sort of other airborne distribution center, not only do you have to have the computer, but you have to have this presentation component. In addition to that, it can't just be presenting information on anything. It has to be presenting information on the things that are stored in the airborne distribution center, the fulfillment center. So unlike just reading the title or unlike just reading the abstract, you really can't make that determination as to what the scope or the scope of protection of this patent is without looking at these things called claims. I don't necessarily recommend playing junior patent attorney as an engineer without some training on it and being trained either on some in-house people or kind of show you how to do this, or maybe your patent attorney can kind of help you do that to kind of give you a better sense of how this is done. But with enough experience and training, engineers and people like that can usually make a pretty reasonable estimation if there's a problem there or not. If it's a little close, probably should talk to your either in-house patent attorney or not. Jacob?
So yeah, what you're saying here is I can have a drop ship enterprise as long as I don't put a billboard on it.
And you could even have a billboard on there, but just as long as your billboard didn't relate to the stuff that's stored up in the airborne fulfillment center. Now, keep in mind, Amazon has a lot of patents. And I can tell you for a fact, Professor Janis knows, they have more than one patent on this technology that relates to other things. So don't think that if you get clear of one patent, there aren't some others lurking in the background that could pose an issue as well. But yeah, you could have your airborne fulfillment center. You could even have a billboard up on there. If you wanted to say, boiler up on your billboard, you have to be selling, I don't know, tennis shoes that aren't Purdue related, that would be perfectly fine in this situation. As long as, you didn't have your your boiler up t-shirts or sneakers up on in the blimp.
There's trademarks, but we don't have to get into that, but.
No.
So one important point to take away then from this is that, of course, as patent lawyers, we look at a claim like that and the underlying language does really jump out at us. That's because we're used to looking at these claims, drafting these claims. We know how to read them in view of the rest of the document, and we understand the concept that these claims define the boundaries of the legal right. But if you're an engineer, how would you know that? So yeah, I think you really have to be cautious, as Professor Hedges says. If someone comes into you as an engineer and says, oh, your assignment is to read these patents, well, of course you can do that. But if they're saying read these patents and tell us what would be infringed by them, well, that's a legal determination that requires expertise, and you just need to realize how much expertise in that area that you don't have as an engineer. Because these documents, while they look kind of like technical documents and they would be familiar to engineers in a lot of ways, the part that sets the boundaries of the patent right, the claim, there wouldn't be any reason for engineers to be familiar with that until you gain some experience. And you really, really want to be cautious about making any pronouncements about what a patent covers, even how it's different from the state of the art, because that all depends on exactly how the boundaries are set through these claims.
The good news is that I got my own patent on this after Amazon did that kind of stuff. And my device does all this stuff, but I got my own patent on it already. So I'm like good to go, right? Because I got my own patent.
Well, I don't know, maybe we should ask the engineering students here, but I'm thinking no.
Oh,
I'm thinking no, and I'm thinking no, those students can tell us why.
It's because, if they have a patent before you and it would be considered prior art to your invention, so it would still be infringing. Just because you have a patent doesn't give you the right to use the patent, it just gives you the right to exclude others.
Right, so that's the easiest way to say it. This property right gives you the right to keep others off your property, but weirdly, it doesn't necessarily allow you to get to your property. It's a strange kind of property right that way, and to think about it in a different way, there could be other patent rights that overlap yours or that dominate yours, and that's the way it works. So getting a patent is not affirmative permission to do anything. It's only gives you the right to keep other people from doing that thing.
that's very confusing.
Very confusing concept, because most times when we think about property, we think that we have the right to possess it in addition to the right to exclude other people from possessing it. With a patent right, you've got the exclusionary rights, but you don't have the possession rights. And that makes the difference.
Darn it.
Yeah.
But you could get the possession rights through a license, right?
You could approach Amazon and say, hey, I'd really like to do this. And Amazon could either say, no, I'm not gonna let you do that. Or they'll say, hey, we'll let you do that for a fee. And then you could.
$1 billion.
$1 billion.
Right.
Is that what Dr. Evil says or something like that?
Yeah, exactly. Exactly. All right, so should we go to scenario number 3?
Sure.
There's one other takeaway, I think, and it just says know how to read a patent document. Understand that it's partly a technical document, but it's partly a legal document that has legal significance for the boundaries of the right. All right, so here's the last of the scenarios. And here's, at this point, you've been working for you did the project with the patent rights, reading the patent documents, you got through that. Now, you've been working for the company for a little while, you did make an invention. Very cool invention. You got a meeting set up with a patent lawyer, and that hasn't occurred yet, a couple of weeks away. Suddenly your supervising engineer sends you a message and says, I need you to stand in for me. I was scheduled to go to the conference and give the presentation, network with the customers, do all that. I can't go. I need you to stand in for me, all right? Now, maybe you say, maybe you're grown and say, like, I don't wanna do that, except it turns out the conference is in Maui. All right, and so, I mean, I feel like you're saying, send me right away. I mean, I'm gonna go, right?
It seems like a good time of the year to
Time of
go,
the year.
to go to Maui.
Good time of the year. And then they say like, well, the conference is gonna be at the Ritz-Carlton Kapalua, which is depicted there, which is cool. That's a pretty cool place. So you're like, this is the great, I'm so glad I went to Purdue and have this degree that gets me to Maui to the Kapalua Resort, all right? And maybe you don't even, you're just excited about the trip. You're not even thinking too much about it until you get there in a different time zone and you can't really communicate with your company. And suddenly you realize, I was told that I'm supposed to give a speech and I'm supposed to say something about this invention that I haven't met with the patent lawyer about. How much can I really tell as I stand up here in the ballroom of the Kapalua Hotel, of the Ritz-Carlton Kapalua? How much can I really say? And you'd hope that you wouldn't be put in that scenario. You'd hope that you can send a text right away and get some details. But it might not be that easy, especially if you're up there and it's the Q&A time and people start asking you questions. I mean, you might have to make a judgment, like how much can I say and how much am I not supposed to say, all right? So let's start with the how much detail can I give? And it's kind of an abstract question, but let me just throw it out to you anyway. All the way from I'm working on this invention, but I can't tell you anything about it, to I'm working on this invention and now let me put all the schematics up on, every part of the airborne fulfillment center. Let me put that up there in detail on the slide. You might figure I can go somewhere in the middle. I mean, where would you?
I'm gonna tell you, if you're all the way over here, where you're not telling me anything, I'm going to the beach.
I know.
I'm going to the beach because you're not telling me anything and it's a lot nicer out there.
Exactly.
I've got my cabana already and that kind of stuff, so I'm out of here. This
Or to the golf
this is a snooze fest.
It's a snooze fest, right? As a young engineer, you actually are under pressure, right, to say something and not have people in the audience be like, oh yeah, I wish the boss came. And instead they send this person who knows nothing. You don't want to do that. There really is pressure to act like you know stuff, all right? So how far are you gonna go, Jacob?
I don't know, I'm kind of nervous and I'd love to send Professor Hedges to his cabana out on the beach because, if we don't have a patent on it yet, I'm just afraid if I say something, someone's gonna come and steal my invention. So
All right.
I don't say much.
Does that seem instinctive to the rest of you? I mean, when we talk to engineers about this and we present that kind of hypothetical to them, very often, the engineers, without a lot of prompting from us, are getting to the right answer from a patent law standpoint. They're saying like, I shouldn't be disclosing details about the invention before a patent application is on file. That is the law, which is shown on the next slide here, which I think says something crazy about bar dates. Yeah. So the law is avoid bar dates. This is what your mother told you, avoid bar dates. That explains the pictures up there. The rule of patent law is in the US, if you make a public disclosure of your invention more than a year before you file your patent application, you're barred from getting patent protection. Now you might say, okay, well, that's great. I can stand up in Hawaii, I can tell them all the details and I can go and then they can file a patent application as long as it's within a year, we're okay. That's great, except that other countries don't have the 1 year grace period. And by disclosing it publicly, you might be wiping out the possibility of getting patent protection in other countries. That would be bad. And so operate on your instinct there. If your instinct is, as it probably is, telling you, I probably shouldn't disclose, maybe a black box, maybe, I don't know. You have to make some hard judgment calls there, but err on the side of not disclosing. The patent law would say that's the way to do it, all right?
Professor Janis, this is a very, very important comments.
Yes, right.
There's gonna be all these people there presenting on all this cool technology because that's what their research is at,
Yep.
and in order to, make tenure and to become well-known in this area, I gotta tell people about my stuff. And so I'm gonna have to catch 22 here, aren't I? I can't talk about it, but I need to talk about it because it's how I get promoted on my job. What do I do here?
So there's a couple of ways to try to deal with this, but many of them involve changing the facts of the hypothetical, because the hypothetical really is meant to put you in a catch-22. So one thing is to say to yourself, you know, I have to have this discussion with the patent lawyer before I ever give this speech. I just must find a way to do that, even if my meeting isn't scheduled for 2 weeks. I've got to get on the phone and say, look, I've been told to give this speech. You got to give me some guidance here. How much detail can I give? Because there is a judgment there. And it is certainly the case that you could give some details without giving so many details that someone else could replicate it. That would probably be okay. The patent lawyer ought to be the one on the hook to make that judgment though, not you, all right? And so that would be one way to try to thread the needle, but it's very difficult. It means, part of the reason we use this hypothetical is that we want to emphasize that just as working as a regular old engineer, you know, you might want to develop a relationship with the company's patent lawyer to a point where, you know, you feel comfortable saying like, hey, I've got an emergency here. Could I just have 5 minutes of your time? Because I'm about to step up on the stage and give this speech and I really need to know. And then they could say like, you know what, just say nothing. People are gonna press you to give details, but I will cover for you because we haven't filed a patent application yet. So if you get some criticism, when you come back, I will be the one to say, I told them, don't say anything. And that would be one way to handle it. You got a better way to than.
Planning ahead.
Yeah.
Granted, this poor engineer got thrown in at the last minute. Hopefully his supervisor who had to back out of it at the last minute was already talking to the patent attorney.
Not true.
And so when the junior engineer calls up the patent attorney in a panic saying, oh my gosh, what am I gonna do? The patent will say, no problem. Your boss talked to me a month ago. We've already got a patent application on file. Just don't disclose anything that's not already in the patent application. Here's a copy, look at it. Just don't disclose anything beyond what's already in there and you should be good to go. Not only have you preserved your US rights, because you're well out in front of this 1-year bar issue, but you've also preserved your right for foreign countries, most of them, by having this filing before you had any sort of public disclosure, all right? So while it's awful that your boss forced you to go to Maui and make this presentation, the good news is your boss did the right thing and got out in front of this, well in front of it, not the day before, not a week before, hopefully at least a month before, to give the patent attorney adequate time to prepare the documentation that needed to be filed. So again, granted, it's awful they had to go to Maui and all that kind of stuff, but you've been taken care of.
Well, and that's what you would hope for sure. And that also, it's a good point that you make, because that's part of the reason why the patent law rule is as harsh as it is. It's the assumption is that people who know what they're doing can plan ahead for these sorts of things, get a patent application on file. It's not that hard. It's a lot of work, but you know, with some advanced planning, it can be done. Emergencies sometimes do come up, but that's why the rule is the bar date and is as harsh as it is. All right. So let's do one more variation on this story. So now the presentation is over. It's time to go play golf. You're on the golf course. And of course, it seems like you're just out there for fun playing at the very expensive Plantation Kapalua golf course.
My favorite course.
It's very expensive. But it's never quite exactly for fun. Really, you're out there, the customers are out there, you're playing golf, you're networking with the customers. And suppose this happens. The customer who's playing the golf with you says, I listened to your presentation and I'm a little fuzzy on the details of how it's going to work because you didn't really say, but you know, I'm really interested in the product. And here's what I would like to do. I would really like to be first in line, our company to be first in line to buy these products. I'm hoping that if we're first in line, maybe you give me a little, better deal on the price, but we're real excited. We're ready to put in a big order. And let's, if we could just talk about a few details here, then, I know it wouldn't be able to be finalized until we get back to the mainland. But we can work out this deal here in Hawaii. We can go both companies. You can go back and be the hero that, got the deal going. I can go back to my company and be the hero. And this is gonna lead to more golf outings. It's awesome. All right? So once again, let me ask you your question, a question about your intuition. Put yourself in the position of being an engineer, a young engineer. And what's your intuition? Is it the same as your intuition that said, oh, I better not, disclose anything? And let's assume that the customer says like, I'm willing to sign an agreement that says that we're talking confidentially here. I'll put it right on the back of the golf cart and we'll sign it, scorecard. So there isn't that. Is your intuition, this would be more benign than standing up and giving a speech? Is it?
So
what your
it's,
intuition-
the president of the big corporation, the engineer, and this is covered by a non-disclosure agreement,
Yep,
confidentiality agreement.
exactly.
And, did I say $50 a unit? Was that kind of what I proposed?
I think $50, yeah,
$50,
yeah.
that seemed like a reasonable amount per unit?
It sounds like, the young engineer is going like, that is good profit margin there. They're gonna love this back home. I am gonna be the hero. I might get a bonus. But, yeah, all right, so what do you think?
I'm still gonna be concerned to divulge in any information, just because
Even under confidentiality?
I would still get some insights from perhaps the patent attorney or something that the business has been doing.
All right, so this is great. So you call from the golf course
Right.
and they don't answer. Because it's the time difference and they don't answer.
They're
and
waiting for you to putt, by the way.
Right,
You
right.
need to be playing ready golf.
People are,
Got people backing up
people
behind you,
backing
waiting for
up,
you to
it's
get off the
bad.
green.
You
Yeah.
said that I'm not supposed to publicly say anything, but if I'm, the other company's fine with me not disclosing more information, we have an NDA, I mean, it seems like I should be able to do it. I still, can get my patent application filed, right?
That
Well,
seems like a,
seems
that seems like a
reasonable
very
idea. You got
reasonable item.
non-disclosure agreement, he said NDA. So yeah, what do you think, Sydney? Same thing?
Yeah, I
So
agree with
it
Jason.
just seems like, so I think that this reaction is pretty typical. Something doesn't seem right because we're posing this to you in a context where you'd think the answer has to be, I'm not supposed to do that. That's always the way it is with lawyers. But yet it does seem different than standing up and giving a speech. So the patent law does not treat them as different. A secret offer to sell an invention constitutes a statutory bar, just as if you stood up and disclosed the details in a speech. It's that harsh. I think that's on the next slide, by the way. It's that harsh. And I think that that's really insidious because I do believe for a lot of engineers, that's not intuitive, that would be a patent defeating kind of event. So that's one reason why we wanted to close with that example, that's just one that maybe you couldn't sort of come up with on your own without us
So
having.
if I did that, I'm ashamed that I did that.
Yeah.
Am I done? I mean, have I just blown all the patent rights here?
So you have not blown the US patent rights, you still have a year, just like you did if you gave the speech with the details, you still have a year. The problem would be again with foreign rights, and it's not clear what the effect of a secret offer to sell would be on your foreign patent rights, but I would imagine most patent lawyers would say, just don't be doing that. Just let us get a patent application on file before you have any of those conversations. And then we won't have to worry about this issue. Is that your reaction too?
It is, I am very relieved, and it's, hitting that putt is gonna be much easier now that you've reassured me that I have not blown.
Taking that off your shoulders?
Yes,
Yeah.
So is the offer to sell enough even if you give no details? So it's a little bit more strict than giving a presentation?
Well, yes, I would say so. It certainly is triggered by an offer. It doesn't have to be a completed sale. The thing has to be in existence, and there are other rules that go along with that. But as an engineer, unless for some reason you've read the cases that give you the rules for these things, there is no way you could know. And the rules that deal with the public disclosures, they're also very finely textured, but you could probably guess at a lot of those. The rules that pertain to the on sale bar, I believe you can't guess your way out of those. So it's just one good example of the kind of thing where, you know, you don't wanna have to mess with that. You wanna avoid that problem, and a way to avoid that problem again is to having some connection, is by having some connection with your patent counsel. You can ask the quick question, send the quick email, feel comfortable saying it's an emergency, I have to putt, I have to know now. And hopefully take away some good advice. So those have been three scenarios that we think are really typical. There are many others where an engineer might encounter the patent system. So don't think that that's comprehensive, but we think that those are three that you could very well encounter right away in your time as an engineer. So it's just about time to close. I think I've got a final question. He wants to come to law school, I'm thinking.
Well, that's my question. I don't know if I'm ready to come to law school, but this patent stuff kind of sounds interesting. Is there any way I can get more involved with patent law as an engineer, maybe make a little bit more money as well?
Well, the money part, so I didn't know you were going there.
Okay.
So the money part, yes, possibly. Because law firms do hire technical specialists who have not finished law school yet, but have the technical background. And that can be a nice, temporary type of position, 1 or 2 kind of year kind of position where you can work as a so-called patent agent. But if you want to do this stuff for real over the long term and get access to the real money, then you got to go to law school, get your law degree, and proceed in that way. Our contact information is up there. If Jacob's question, you know, triggered your interest and you want to know what, you know, what I could be doing at Purdue to think more deeply about this career path or just learn more about it, send us an email. We'll be glad to answer your questions about that. Otherwise, we're just about over time here. We'll close, and thank you again for inviting us to do this. It's always fun to work with Purdue students.
Absolutely.
Boiler up.
Roll her up.
All right, we're done.